So welcome to another video where now I'm going over what we call SOFA, but a statement of financial affairs. This is when you're getting towards the end of the bankruptcy petition. Of course, we still got to get to the big one, which is the means test. Now, as always, and I've said with every other video, and you can see all the other videos on my blog, bankruptcy.blog. On the bottom left, there'll be a section there called How to File for Bankruptcy, where you see all the other videos where I'm reviewing the bankruptcy petition. Now, for statement of financial affairs, I'm going to do what I've done consistently, and that is I'm just going to go over issues to be concerned about. I'm not going to tell you how to specifically, complete the form because, I don't have your name, I don't have your district, etc. So it's more important to focus on the issues because a lot of the stuff is just self-explanatory, but it's the issues that you have to catch in order to make sure you don't make any mistakes. Okay. So of course, we'll start off with the basics. When you have a bankruptcy program, it asks you this question before if you're married or not. And then what happens is if you don't check it off on this, then you have to do it. It's not going to let you prepare the final petition. So keep that in mind that if you had to do that before in the petition, to go back and make sure everything matches. Why should everything match? Because I'm a big believer that when there's one thing that is wrong, then the trustee is going to ask other questions and say, well, what else did you get wrong? So that's just the reality of the situation. Now, when we're coming here to this section, where else have you lived? The reason the court's asking for this is, for one, to see if there's any other property out there. For example, maybe there's homestead property, and let's say right here, this one is your homestead. And so you put this address here, and now you put, your current address at the beginning of the petition says something else. Well, if you're renting out your homestead property, then that house is not going to be protected. I've written blog posts on this issue before, but you cannot confuse what is homestead protection regarding, the county tax appraiser's office versus what is homestead protection in bankruptcy. And by the way, in the county property appraiser's office, it's the same thing. You have to live in that property in order to claim homestead. But that's what the trustee is trying to figure out here. Is there any issues really? Presents. Why is there two different addresses? Why does your address on your driver's license not match the address that you have now? Did you recently move? Why did you move? And then that just leads to more questions. For example, if you gave a deposit and they find out with your landlord, he says, well, I just moved recently. They're going to ask, what was the deposit? When you say $4,000, the trustee is going to say, where did you get $4,000 from? So you see how one thing leads to another. And so that's why you have to know what these issues are in advance. Now, this one here is just community property issues, so I'm not gonna dig into that. But of course, community property is treated somewhat differently than what comes to what we call, the majority of the states, equitable distribution states. Now, here, why are we going over your income again? Well, your income initially in Schedule I, which I already gone over, is really dealing on the income of the month you're filing. So today is the 17th day of the month. So Schedule I is going to focus on this whole month, even though the month hasn't been over. You kind of guess the remaining 13 days. The problem with this and the means test is also different because that's the last 6 months. I'll give you an example. I once had a client who had close to $200,000 listed the year before in income. And all of a sudden, we're in bankruptcy court. That's going to lead to questions from the trustee. How'd you go from 200,000 to filing for bankruptcy? The trustee is just trying to figure out, is there something here worth looking into? Chances are 99.9% of the time it's legit, but they want to make sure there's not something else there that all of a sudden this person is earning less income, maybe hiding assets, etc. So it's really nothing more than that. My client's case, simple enough. He was a realtor. He had that very one good year prior to the mortgage crisis. And then once the mortgage crisis hit, everything was gone. So, but that's why they have to ask those types of questions. Now, if you see here, it's asking income from employment or operating a business. Why is operating a business important? Well, simple enough. Did you list that business on a Schedule I as income? Was it listed as an asset too? The business might have certain assets. For example, lawyers, we really don't have assets, right? Unless you own a building, just computers and things like that don't really have much value. But what if you're in another type of business? What if you're a dentist? Now you have dental chairs. You have all the tools and equipments, things that cost money. And so they got to make sure that that also was listed. I suggest you look at prior blogs that I've done in videos regarding LLCs. A lot of times people say, well, they can't touch that because it's a business and it's an LLC. That is an overly simplistic view of how LLCs work. It doesn't work that way. In bankruptcy court, at the end of the day, that is your asset. And if that asset has a value and the value is of interest enough to the trustee, it's not going to be protected. And then they're going to come after you to pay back the value of the business or shut it down and liquidate all the assets. So keep that in mind. Stop with the LLCs. Nobody can touch it. That is just completely not true. It's just misinformation has been floating around since LLCs first started. Okay, so now they're looking here at any other forms of income, and it says clearly. You see that it'll say alimony and child support. I'm surprised it still say alimony. Nowadays we say spousal support. Uh, Again, was this listed in Schedule I? Schedule I specifically has a section that asks that. And if not, it's going to ask whether at least there's any other form of income. And you're going to have to put in there child support and alimony. Why? Because again, it changes all the numbers. An extra $500 a month in child support could completely, put you in a situation where you don't qualify for bankruptcy because you have all this disposable income, which brings up an issue that too many clients don't realize when they're going over, especially if they're doing on their own. They say, well, I don't have any money left over, so I qualify. You don't have any money left over if you're including all your expenses, which includes your credit cards. You can't include your credit cards as an expense because that's the whole point of bankruptcy. You're wiping out that debt. So when you're doing the calculations of income, Schedule I and Schedule J expenses, you cannot include whatever that magical number is on credit card debt. You have to have minimal disposable income after excluding that. All right. So keep that in mind. Now, here are the types of debts. Basically, we're just trying to confirm again, is there an issue? If there's any business related, if a person puts no, all my income, or all my debts are related to a business, then again, we have to, the court's going to reevaluate, or the trustee, why this type of bankruptcy was filed. Okay. Now, consumer debts, that's your typical debtor, so nothing else to learn there. Now, why is this important? Well, a lot of times we'll start first with the insider. And an insider, the best way I like to say it, and you see there it asks, it gives you literally a definition. I just like to say friends or family or those you're close to, did you transfer any property? This is an issue. I can't file for bankruptcy and they say, well, I'm just going to transfer everything to my best friend. And then once we're done, a few months go by, everything's under control, then I'll have them transfer everything back. That's why they ask this about insiders. This is especially an issue. I even wrote about this in my bankruptcy law textbook, where a lot of times it's around the tax season, where they ask, how much did you receive in taxes? And then you say, it's a large amount, $5,000. And they say, where did the money go? Well, I had to pay my cousin. Even though I had one case where I asked the client, why did you say that? The truth as to where the money spent was good enough. She got nervous. She thought she seemed irresponsible. So instead, she said she paid someone that she never really did. So guess what? She had to pay that back. That's considered an insider. You're transferring all these assets to an individual, and it looks like you're basically trying to get away from having to, for having this property that's probably not exempt. You're trying to protect it that way just by a transfer. That's an issue I could tell you happens not only in family court, but even in bankruptcy. When I interview a client, they always say, well, can I just transfer everything? And the answer is no. It's not that simple. It's not like they're not going to know. And it's not like they're not going to take any actions if you did. Okay. And the other reason as well, there's sometimes, and I'll get that to in a second, if you're negotiating with a debt management company, one of these companies that's trying to help you get back on track, sometimes these payments are kind of big. And if you did a payment right before filing for bankruptcy, it wouldn't be surprising to have the trustee go after them for that payment. All right. So did you transfer 1 year before any property on the account of a debt that benefited an insider? Again, is there any transfers of real estate, personal property? That's what they're trying to look at. Now, were you a party to a lawsuit? Typically, a lot of times what happens is the bankruptcy is being initiated because of just that, a lawsuit. A credit card finally said, let's sue you. I've always felt that when it rains, it pours when it comes to credit card lawsuits, because when one creditor finds you, then they all seem to find you, and then they all start filing lawsuits against you. So typically, if you have one, you're probably going to get two or three down the road real quick. All you got to do is list the type of debt. You just say it's a credit card debt. I'm going to focus on this right here and just say concluded. A lot I've heard. It happened to me once where a creditor called and says you can't include in bankruptcy a judgment. And that's a preposterous statement. Just understand that most of the times creditors are not going to give you the truth. They're not there to protect you. They're not there to protect your self interest. They're there to make money, their commission sales, whatever it is, however they get paid. They're not going to tell you what you want to hear. So keep that in mind because sometimes people get confused and says, well, I have a judgment. I can't include that, right? The answer is you absolutely could include that. But why would that be a big deal? Okay. Same thing. Any question, anything has been, any property has been repossessed or foreclosed. You might wonder, well, why would this matter? Well, a lot of times you do have a foreclosure, and the person says, I'm letting the house go, and then by mistake, well, they find out. Well, not by mistake, but they ultimately find out that there's a surplus. So they owed 100,000 on the mortgage, and the house sold for 125 at foreclosure. Guess what? That 25,000 belongs to the trustee, belongs to the bankruptcy estate. So that's why they're asking here if there's any information, that potentially, again, I always like to describe the trustee in a very simple terms. They are there to make money, find money. And the only way they can do that is by going through all these issues and trying to find out. Okay. Now, 90 days, I consider this ignorance and controversial. Too many times you see people, and I'm going to focus on these two dates here. They see these two dates of 91 year, and they say, as long as the client's outside of that, then we're good. And then we can actually even go for one more down, 2 years. So they say, well, I had a condo and I transferred it to my son or niece or nephew. They say, okay, well, at 2 years and a day, you can come and file for bankruptcy. No, it doesn't work that way. You don't transfer a property. And I had that issue once in practice. The client didn't tell me that has been paid off in full. Transfer that, then buy another property and claim homestead, under Florida's generous exemptions, and then forget the other property that was transferred. This doesn't mean that the trustee cannot go back further than these dates based on state law. So a trustee might say, and I've seen them where they say if you transferred any real estate and they or even other assets and they give a certain number more than $10,000 in value within the last 10 years. So now it's no longer 2 years, it's 3, 4, 5, 6, 7, 8, 9, 10. So that's why I see too many times lawyers give that advice, or they say, well, don't worry about it. You use the credit cards after 91 days. Really? So if I go buy a $2,000 laptop, I'm okay on the 91st day if I made the payments on it and everything else? No, the trustee is going to object. The trustee is going to have an issue. They're going to say the laptop, you're going to have to repay back its value or maybe even the full amount. So everything else will get wiped out, but that won't. So keep in mind that while these dates are important, it really depends on the facts of the case. You can't spend $50,000 and then say it's only been I've been making payments, big payments. I can go ahead and skip, go straight to bankruptcy. No. Likewise, I did a transfer, but it's been more than 2 years. I'm okay. No, it's very fact specific. I've had clients that I've had to say, for example, you're going to continue making minimal payments on your credit card for a full year, then come back to me. Another client might have spent less, might not have any assets, and I might say, don't worry, come back in 3 months or 6 months. It really just depends. These numbers are not set in stone, especially we're dealing with issues of fraud, issues of using your credit card way too much prior to file for bankruptcy for literally luxuries. I've had clients who come in and say, oh yeah, I just spent $10,000 last week on furniture. And say, yeah, well, that's not going to get included in the bankruptcy. You can forget about that. So just keep that in mind. These dates are not set in stone. Okay. Now, losses. I tend to avoid those when someone comes to me and says they lost 70,000 in a week. I pretty much say, come back in a year. I'm not gonna. This is not gonna be worth it. Um, but you're going to have to prove these losses. You just can't, this person was actually getting credit cards, cash advances. There's no receipts. Then he started buying computers and he was hawking the computers, all this for gambling. Is it true? Maybe. Am I going to deal with it? No. It's going to be too problematic. But there could be other issues like theft or fire. And the only issue there is Sometimes people cut corners. The insurance company comes in and says, well, here's $20,000 for your kitchen. And they say, I'm going to go buy all the stuff myself at Home Depot for $5,000. I'm going to pocket $15,000. Yeah, the trustee is going to have a problem with that. You don't get to keep the $15,000. You're just better off hiring someone, spending the full amount, and then you don't have to worry about these issues. All right. Now, this goes back to what I was saying about sometimes you're paying these debt management companies to help out. And that's why they're saying, were there any specific transfers to bankruptcy petition preparers? A lot of time, bankruptcy petition preparers are not fully schooled on how to do this. And I've seen the courts take action against these people because they've done the bankruptcy petition wrong. But that's what they're trying to find out. I mean, I literally had one client who was paying a petition preparer for Chapter 13 to keep them out of foreclosure, and the payments never went to the court. They went to the person's pocket. Of course, you go to the business is gone. It's a fly-by-night, so these things happen. Now, it's not just these debt management companies, but they also ask if you paid any attorney as well. And of course, we put there the payment structure. I got paid $500 a month for 3 months. We list that as well in a bankruptcy petition. There's a separate section for lawyers for us to have to do that. Okay, so the rest is just the same thing. Transfers, as you can see here, 10 years, like I said, and a lot of states. What happens is trustees will focus on state statute if they have to, in order to what we call claw back and get funds from before. Okay, now, safe deposit box doesn't mean that you're going to lose everything. The only issue is there's anything there. Storage units. That's why people need to understand clearly that it's not just you file for bankruptcy. For example, I had a client with a storage unit, and I started asking more questions. Found out he had a business. He had a business with plenty of equipment. So that's why these trustees ask these questions, because one thing leads to another. Now, if there's a safe deposit box, as long as there's nothing there, then that's fine. Most people have safe deposit boxes, but there's literally nothing there. It's just something that's offered for the bank. Now, this is kind of weird. Somebody holding property for you, probably not, but it's just there. Just answer it accordingly. Not a big deal. These environmental issues, chances are it's not going to apply to you. Maybe we're dealing with a farmer's bankruptcy potentially, or some sort of other type of business, but not your typical case. So no need to focus on that anymore. And again, this right here, is there any business? Why? Because again, the business is not protected. If it's not protected, then the issue is, what is the value of that business? And based on that amount, which is not going to be protected, then the trustee can go forward. Of course, they are asking as well, the employment identification number and who is running the books of the business. Now, as we get here to wrap it up, as you see, all you got to do, what's left is just sign off on this, and this gets filed along with all your other documents. So when it comes to statement of financial affairs, what I want you to understand is make sure that everything lines up, whether it's just something as simple as listing a property. When I've had clients come in and their address doesn't match what's on the license, then I tell them, you better go and fix this issue now, because when we go to court, the trustee is going to say, come back in 7 to 10 days with a new license. If you're living somewhere else, you're supposed to change your license typically within 10 days anyway. If not, a police officer can give you a ticket for that. But if not, now you got to miss court again just to go down and say hi to the trustee. Nowadays it's Zoom. Maybe they'll accept an email, but a lot of trustees still have the option. Not a lot. They all have the option of having the 341 meeting in person. You don't want to miss work just for that. So just get it done. Make sure all these little things match up, and then just be prepared. If imagine if you have a person who's tax returns are saying one address, the driver's license is saying a second, and where they're getting correspondence today is a third. All that has to be lined up. Make sure, I don't even care if you have a lawyer, they don't always catch on these issues, so make sure that everything is lined up so there are no issues down the road. All right. Any questions or comments on the bankruptcy petition, especially here, SOFA, feel free to comment in the comment section below. And remember, you can see all the other parts of the petition on bankruptcy.blog.